Well, good day and welcome back. Employment Law Show. Good to have you along again this week. John Scholes and founding partner Samfiru Tumarkin LLP, the most positively reviewed employment law firm in the land. That is Lior Samfiru. Good to have you here. I know you've got questions. You're probably waiting for the show thinking, I've thought about 10 different things. We might cover it on the show because we take emails, we take phone calls from the radio show, all kinds of websites we have offered up for you, absolutely free for you to answer your questions. So we'll get to a bunch of that today, including 5 things to know about employment contracts. What contracts? Exactly. You may not have one, which might be a good thing. We'll get to that later. But we always start with the phone call. If you need to make it anytime, 1-855-821-5900, help@employmentlawyer.ca. That's the email address. Here we go, pal. What do you got to kick us off?
Well, John, it's really been another exciting week. And anytime I get to answer people and talk to people, to me it's exciting. I enjoy doing that. I like to help people, and mostly I like to educate people on their rights. That's why we're here on the show for the next 30 minutes, to educate you on your rights. You may not know a lot of the things we talk about. You may not realize the extent to which you have rights, you have entitlements. There's things that you can do. There's options that you have. Well, we're here to educate you on those and tell you what you need to know, whether you've lost your job or worried about job security. Maybe you've been told to train your replacement. What can you do about that? Maybe your boss is not treating you properly, trying to get you to resign. Should you resign? Let's talk about that. And of course, severance packages, we deal with that on every show, and I deal with that all the time in the office. And if anything that we say or anything you learn today triggers something, raises more questions, there's more things you want to discuss, don't hesitate. You can always reach out to me in the office. Happy to have a chat with you privately. We'll give you that contact information throughout the show, so stay tuned for that. But I always like to start off with a situation or an interesting question that I got throughout the week. Well, probably the biggest question, one of the biggest questions I've been getting over the past number of weeks has to do with being put on an unpaid leave of absence. We've been hearing that a lot in the context of vaccinations. For those employees that have not gotten the vaccine, we see employers putting them on an unpaid leave of absence. So I've been getting the question, well, can they do that? How long can they do that for? And what are my rights generally? So let's start with the idea that an employer never really has the right to put you on an unpaid leave of absence. An unpaid leave of absence could also be considered a temporary layoff. Anytime you're not working and not getting paid, you've been laid off. And there's no right for an employer to do that. Meaning, if you've been put on an unpaid leave of absence, you have really 2 choices. Choice number 1 is you can accept it, and you can wait at home and hope that at some point your employer changes its mind and calls you back to work. Obviously, that is your right. And how long are you going to be on that unpaid leave of absence? I don't know. It's going to be until your employer decides to bring you back, if that happens. So all that is option number 1. Option number 2 is very different. Option number 2 is that you make the decision to treat that unpaid leave of absence as a termination of your employment. We call that constructive dismissal. You can say to your employer, no, I'm not accepting that. By putting me on this unpaid leave of absence, you've terminated my employment. Now you have to pay me severance. That is true anytime your employer puts you on an unpaid leave of absence, and it's certainly true these days with respect to vaccines. So if your employer puts you on an unpaid leave of absence because you didn't get the vaccine or you didn't disclose your status, that is a right that you have to treat this as a termination. Now, there's 2 exceptions to this. Number 1 is if you're a unionized employee. None of this applies to you. By the way, nothing we really talk about on the show applies to unionized employees. It applies to non-union employees. And the second situation is if there's a government mandate that applies to you. So if your employer has no choice but to put you off work because the government has intervened and imposed a mandate, that's different. There's not going to be much that you can do. It's not going to be a constructive dismissal. But if there's no government mandate, and 98% of employees don't have a government mandate that applies to them, so if there's no government mandate, constructive dismissal should come to mind. Your employer does not have an automatic right to put you on an unpaid leave of absence.
Does that change if it's an unpaid suspension for whatever work reasons? Maybe you messed up and they're saying, we're going to put you off work for a while, but we're not paying you.
No, it's exactly the same. An employer also doesn't have a right to put you on an unpaid suspension. That said, if your employer says you did something wrong, I'm going to put you off for a day or 2, for a suspension of a day or 2, there's probably not going to be much that you're going to want to do, even though, again, not necessarily something your employer is allowed to do. If it's a day or 2, we may let the employer get away with it. But if it's an indefinite suspension, no. No reason to do that, no reason to accept it. They don't have a right to do it. You can treat that as a termination.
I guess you said in the past that if they do that sort of thing while they investigate what you did wrong, they've already punished you because they're not paying you.
So some employers say, well, there's an allegation you did something wrong.
Right.
We're going to investigate that. While we're investigating, we're going to put you off on an unpaid leave of absence. No. Unpaid leave of absence is a disciplinary measure. So you're disciplining someone while you're trying to determine if they should be disciplined. It's one thing to say, while we're investigating, we're going to put you off work on a paid leave of absence. Sure. But if you're going to punish someone by not paying them while you determine if there should be punishment, that's wrong and that's illegal.
Employmentlawyer.ca, that's always the website you want to go to, with all things considered with the firm, as well as how to find a radio show near you across this country where you can catch that pretty much on a weekly basis, if not more than that, for an hour at a time. Lots of good information. We always get a ton of phone calls from listeners on the show. Some of them are so good and interesting, we'd like to play them back on our TV show. So we're going to do the first phone call for today right now.
Now, I'm an employer, small business. I'm an employee who's 62 years old. Been with the company for 5 years, is not working out. It just seems like this particular employee is getting progressively worse and worse and making mistakes. I feel like I have no other choice but to terminate this employee, and I know it's going to cost me severance. What could I expect to pay for
So it's a good question. We get a lot of questions from employers as well on our radio shows, et cetera. So let's answer that. If he wants to try to let this employee go without severance, that employer has to do some work first. Clearly, this employee is making some mistakes, not doing a good job. So the employer has to do some work before it could terminate him without severance. That means it has to provide some warnings. It has to provide something in writing saying, here's what you did wrong. Here's what we need you to improve. And by the way, if you're not going to do that, we're going to have to consider letting you go. You have to have these, let's say, 3 warnings, and then if the employee is still not getting it, still making mistakes, still doing a good job, maybe then he can consider terminating that employee for cause without any severance. That's difficult to do. On the other hand, if that employer doesn't want to put in that work, they just want to let the employee go now and just pay him what he's owed, well then sure, that employee is owed severance. And it's important to remember that even if that employee is making mistakes and not doing the best job, if he is let go, in most of those cases, he's going to be owed severance, his full severance. So the question, of course, becomes how much severance? Well, let's go to our friendly tool, our user-friendly tool, pocketemploymentlawyer.ca. Let's plug that information into the severance calculator, and let's see right now how much severance this person, not doing the best job, but how much severance he's owed. So we know that this person has been there for 5 years, 62 years old. His employer is wondering how much severance. Well, you see at the bottom there, he's owed 8 to potentially as much as 10 months of pay. Okay, 8 to 10 months pay potentially is what is owing to this employee. Now, this assumes that the employer is not inclined to put in the time and the effort to try to build up a case for cause. They just want the employee gone. And by the way, if you're an employee, if you did something wrong, does not mean that your employer can just let you go without severance. In most cases, full severance is owed.
So this employer has to do their homework if they want to get out without spending a penny, but if they got the bankroll, it's going to cost them 8 to 10 months, almost 60,
8 to 10 months. And remember the rule that an employer can generally let you go at any time, but, and this is the big one, severance has to be paid. And for this guy, it could be as much as 10 months pay.
TerminationQuestions.com, yet another resource for you to use, absolutely free and anonymous. Ask your questions there. They will get answered by Lior or a member of his team. Martin, first one for the day, says, I was told I had to be fully vaccinated against COVID-19 by a certain date. I love my job, so I decided to comply and got my first shot. Unfortunately, I couldn't get the second one until after the deadline. My boss initially gave me an extension, but then changed her mind a week later. I was fired once the deadline hit. Do I have any rights?
Well, the right that Martin has is the right to get severance. Now, I may say, well, his employer could have and should have maybe given him a few extra days to get that second shot. Ultimately, we can't undo that. We can't make his employer give him more time. It's simply a question of dealing with the termination. And by the way, the same thing applies to you. If you've been let go while you're on the fence with respect to the vaccine, we can't undo that termination. We can't stop your employer from terminating your employment. What we can do is make sure that your employer pays you severance. They may not do that off the bat. They may say, no, it's a health and safety issue. We're going to have to avoid paying you severance. No, in most cases, severance still has to be paid. Same with Martin. Can't do much about it, but he's still going to be owed severance. I don't know his age, his position, and his length of employment. If he's a long service employee, that could mean as much as 24 months pay owed to him. So Martin should give me a call so we can chat a bit more about what his actual severance entitlements are.
Also coming up, what you need to know about employment contracts, a busy segment coming up, so make sure you stick around for it. In the meantime, Lior just mentioned the phone number to call, 1-855-821-5900. Email works as well, help@employmentlawyer.ca. We'll continue. This is the Employment Law Show. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. John Scholes, Lior Samfiru, reaching out to Lior anytime. Again, 1-855-821-5900. The number, help@employmentlawyer.ca. Samfiru, Tumarkin LLP, the most positively reviewed employment law firm in this entire country. Okay, this is really important stuff. We're going to talk about 5 things you need to know about employment contracts. You may be on the cusp of signing one. You may have signed one and been sitting on it for years. You don't, or maybe you don't have one. We don't know, but it's really important that you get this information down. Number 1. I love this one right off the top. It is you are likely better off not signing an employment contract. Most people are saying, wait, what?
Yeah, so let's start by explaining that we're using the term employment contract, an employment agreement, a job offer letter. Right. They're the same thing. Yep. It's a document that you sign usually when you start a job outlining terms of employment. Now, I know people are shocked by that. I know it because I've talked to hundreds of people on this issue. For an employee, it is far, far better not to have an employment agreement. To start a job on a handshake, grab a napkin, jot something down, that is better than having a 10-page document. I assure you, for an employee, for an employer, much, much, much better to have a properly full, robust employment agreement. So for an employee, the reason why it's better not to have an employment agreement is because the law already provides good rights that you have. You have some significant rights. They're there whether you realize it or not. The only thing an employment agreement does is either eliminate some of the rights that you would otherwise have, or even worse, it takes them and it gives them to the employer. I'm going to give you some examples. For example, the law says your employer cannot change the terms of your employment. They can't reduce your pay. They can't change your job responsibilities. But an employment agreement can say, yes, we can do that. We can change your job responsibilities, your hours, your pay. And if your employment agreement says that, you're fine. Your employer can do it. Your employment agreement may also say that your employer can eliminate most of your severance if they let you go. Without that employment agreement, you could be owed 24 months' pay. You sign an employment agreement, that 24 months becomes 8 weeks' pay. It could cost you tens, if not hundreds of thousands of dollars. That's just 2 examples, John. There's many others. So for an employee, don't insist on that 10-page document. An email from your employer is good enough. A handshake at the coffee shop is good enough. You're better off as an employee not to have an employment agreement than to sign a lengthy and extensive one.
Number 2 is this: just because there's a termination clause in your contract, it does not mean it's always enforceable, right?
So, exactly. And I touched on the fact that one of the things an employment agreement tries to do is to reduce your future severance entitlements. You may sign an employment agreement that tries to eliminate the majority of them. Now, the good news is that for most people, for reasons I'm not even going to get into, those terms or those termination clauses are not enforceable. Our courts have decided that in many cases they're not enforceable, meaning you're still owed your full severance. So, What I want you to, number one, to do is, first of all, don't sign an employment agreement thinking, well, it's not going to be enforceable, so I'm going to sign it. That's a bad idea. But if you did sign an employment agreement and now you've lost your job, don't assume that just because your employment agreement tries to limit your entitlements, that it in fact does so. In many cases, it does not. So we have to sit down and review it. You can send me a copy. I can take a look, and I can tell you in 30 seconds flat whether or not that termination clause limits your entitlements or whether we can disregard it and then you can still get your full severance.
We're talking about, well, this time, 5 things you need to know about employment contracts. Number 3 is this, and you've already talked about it. We'll dig a little deeper. Your employer can't make unilateral changes to the terms of your contract.
So if you sign an employment agreement that provides for certain rights, certain benefits, compensation, your employer cannot change those unilaterally no more than you can. So if you've agreed to a salary of $90,000 in your employment contract, you can't just walk in and say, tomorrow you're paying me $100,000. It would be nice.
Right.
By the same token, your employer can't say, tomorrow you're making $70,000 because we have a contract that says $90,000. Now, the exception to that, I touched on that earlier, is if the contract specifically says your salary is $90,000, but we, the employer, have the right to change that. That's a very bad term to have. If you think about it, essentially what you're agreeing is you'll pay me whatever you want, employer. No one is going to want that, but in most cases, people don't even realize that that's what they've done. So your employer cannot make significant changes to terms of employment unless the contract allows them to do that. Anytime your employer changes those terms, you should think constructive dismissal. You should think about the idea that you can treat that change as a termination of your employment and get severance. Of course, before you jump ahead and do that, you always want to run it by me to make sure that what your employer did was in fact a constructive dismissal. But no, an employer can't say, my contract, my company, I'm changing it. No, that's a constructive dismissal in many cases.
2 more of these to go, but just as a little sidebar, it's just becoming abundantly clear that there's so much more to employment contract than just how much am I getting paid, when are my holidays?
Most people, they look at that, right? I want to make sure my salary is right.
Yep.
It's very important for me to get my 4 weeks vacation because I want to take a vacation with the family. I understand that. I also want to make sure that I'm going to get a nice bonus. And they look at those things and they forget everything else. Well, think about it this way, John. You may have signed an employment agreement that says, we can let you go at any time for any reason. Oh, and by the way, if we do that, we're only going to pay you 2 weeks' pay, and you can't compete in the industry for 2 years. Do you know now why we can't just look at salary and benefits? There's other things you have to look at, which is exactly what we're talking about today.
Number 4 is this on the things you need to know about employment contracts. The company can't force you to accept a new employment contract.
So you've already been working for a company, you've been there for a number of years. All of a sudden, an employer comes into you and says, now we want you to sign a new employment agreement. Here's a new one. Please sign it. And we're asking others to sign it as well. That's always bad news. I have yet to see in 20 years of doing this a situation where the employer walks in with a new employment agreement so that they can provide you better terms than what you had previously. It's not going to happen. The reason why your employer wants you to sign a new agreement is because they realize that the previous one, if you even had a previous one, was just not good enough to protect the employer, and they want something more robust. They want to take away some rights they would otherwise have. It's a bad idea to sign it. You can sign that agreement, and then if a month later you're let go, you could be walking away from tens of thousands of dollars of severance just because you signed that agreement. Remember, your employer can't punish you. You can't be fired for cause for refusing. There's a good reason not to sign it. If you're not sure what it does, what it says, should you sign it, send me a copy. Let's chat about it.
What if someone say, well, I signed the first one 5 years ago. I have to sign this one.
Absolutely not. No. Whatever agreement you sign is the agreement that you've signed, and there's absolutely no reason. And now sometimes your employer may say, well, you know, we're going to be giving you a pay raise. Great. Everyone likes a pay raise, so we're going to increase your salary by $2 an hour, whatever it is, but you have to sign a new employment agreement. Again, be very suspicious because it's possible that that extra $2 an hour is more than offset by other terms that are going to cost you tens of thousands of dollars. So in some cases, it may be better off to say, thank you for the raise. I'll decline because I don't want to sign that agreement that's going to cost me a lot more than that extra $2 an hour.
That brings up a good point, though. I mean, if you do decide to sign it, if it all works out to be okay, don't they have to give you something, consideration for signing the agreement, or it means nothing? Right?
Yes, exactly. If your employer does want you to sign a new agreement, you've already been working for the company for a while, now they want you to sign a new agreement, they have to give you something in return for signing. A pay raise, a signing bonus, extra vacation, something that you would otherwise not be entitled to. But just because they're offering you that doesn't mean you should sign it. In many cases, you're still better off not signing it, declining, and not giving up your rights.
All right, 5 things you need to know about employment agreements. Number 5 could be the most important, and this one's the easiest as well. An employment lawyer can simply review your agreement and tell you whether it's good or not, or negotiate terms, right?
An employment lawyer, right here, exactly. The reality is that I review a lot of employment agreements, and it's always a good idea. If you're starting a new job, let me take a look at the agreement. Let me tell you what you need to know if there's a problem there, how we can negotiate, what offer or counter proposal you can make to your employer. You should always be mindful of what you're signing, okay? Certainly, if you've already been working, as I said earlier, and now your employer wants you to sign a brand new employment agreement, before you sign, before you even think about signing and whether you should, send me a copy. Let me review it. Let me tell you what it means, whether you should sign, what it changes, what it doesn't change, so that you're informed. Always happy to do that.
And I know you work with a lot of employers as well, drafting proper agreements on the flip side. But, you know, having said that, if an employer is a little bit lazy, maybe doesn't have the resources, says, I'll just get a document off of Google and I'll use that. You know, employment document 101, sign this. It's not always enforceable. It's not legal.
No, it's not. It's okay to go to Google to find out how the Maple Leafs did last night in the game that you didn't watch. Not a good idea to go there to find a copy of an employment agreement that you can use for your business. Please don't do that. It's a waste of time. You're going to find things that are completely inappropriate, that are not going to help you, that are out of date, that are going to cost you money. If you want a proper employment agreement, speak with an employment lawyer, do it properly.
Employmentlawyer.ca. Again, that's the place you go to catch our radio show. Phone call number 2 for today is coming up right now.
I work for a manufacturing company in an office. They laid us off. 2-3 months later, they called us back again. They moved me to a different department. I didn't change my salary or anything. A couple of months ago, they moved me again to another department. Now, it's under a new management, and it looks like these guys are getting rid of the old regime slowly. I've been there over 30 years. I don't know what my options are here.
So, John, sometimes in a situation like this where someone's job is being changed, different departments, we may want to think about constructive dismissal. That's probably not an option for him because it appears that there's a history there of moving him around, putting him in different departments, giving him different jobs. So not much that he can do about that right now. But he says that they're kind of getting rid of the old guard and they want to bring new blood in. The reality is that there's not much you can do to stop that. An employer can make these changes. They can let you go. Even though you're the most senior person there, even though you may be better at your job than someone else, if they want to let you go, you can't stop that. They're allowed to. But of course, they have to pay severance. Now, this person has been at that manufacturing facility for some 30 years. He's going to be owed right around 24 months' pay. So my best advice would be don't quit. Don't leave. If you quit your job, you're not going to get any compensation. Do your job to the best of your ability, and if and when the time comes that they let you go, that 24 months is owed to you. If you don't get it, you call me, I'll get it for you. That's what you have to do, but the worst thing you could do is on the eve of being let go, on the eve of receiving significant severance, to just resign. Don't ever do that.
Another phone call coming up, but a break first. We'll get to it now. In the meantime, the phone number to call Lior and his team, 1-855-821-5900. Email we use is help@employmentlawyer.ca. More Employment Law Show is coming up. People think contractors aren't owed severance. Employmentlawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back, Employment Law Show. A couple minutes to go. Let's squeeze in our third and final phone call from our radio show on this show right now.
I had an episode where I collapsed and I spent 6 weeks in hospital. The young fellows that I hired, I was asked by my employer to start training them up. He took over my position. I've been told several times that there were projects all over the province. I offered my services. My employer said, well, subsequently, I've not been allowed to come back to work.
That's nice.
Well, I mean, not a good employer there, is there?
No.
So the first thing I'd want to understand here is whether or not the fact that he's essentially being let go and put on the layoff, whatever you want to call it, whether that has something to do with his medical condition. He had a medical condition, he collapsed at work, he may still not be healthy, and if that's why his employer is saying, you're out of here, well, that's a human rights violation. You can't do that. So beyond just severance, he could be owed human rights damages. In some cases, he may even be able to get reinstated because what the employer did is illegal. Same with you. If you're being mistreated, let go, your employer won't work with you because you have a medical issue. Well, again, that's a human rights violation. That's not legal. Now, if the reason his employer is putting him off work is not related to his medical condition, maybe he's now in perfect health, then it simply becomes a regular termination and he's owed severance. Training your replacement in and of itself, as uncomfortable as it is not illegal. If you lose your job, your employer has to pay you severance. That's really their obligation. So there's a lot to discuss here, but I wanted to remind everyone, number one, you can't be let go, you can't be laid off, you can't be put off work because of a serious medical condition. You have to be accommodated. Your employer has to give you the time to get better. Otherwise, it's simply a matter of severance.
Got time for a terminationquestions.com question from Ishan. Ishan says, I was wooed by a competitor to join the company as a senior manager. After a year, they felt it wasn't working out and offered me 2 weeks' pay plus another 2 weeks if I accepted the offer within 5 days. Is that a good deal? I'm 48 and made $120,000 in my first year.
So we know that he's been there for a year. And remember what I've said often on the show, that short service employees are treated disproportionately better than long service employees. Now, there's another factor here, that he was recruited from another job. If you're recruited from another job and then let go in the first few years, you may be owed enhanced severance that recognizes the time with the previous company. So there's that to consider. But even on the basis of just 1 year of employment, he's owed a lot more than the 4 weeks that he's been offered. Let's go one last time to pocketemploymentlawyer.ca. Let's use our severance calculator tool, and let's see how much compensation this person is actually owed. So we know he's a senior manager with just over a year of employment, 48 years old, and his employer believes maybe that generously 4 weeks is all he's owed. You can see at the bottom of the screen he's actually owed 4 to 6 months' pay. 4 to 6 months' pay, and that could be even more based on the fact that he was recruited from another job. So yes, John, even after 1.5 years, he could be owed as much as 6 months' pay. Same with you. If you lost your job, 6 months' work, 2 months' work, a year, whatever their short service, your severance often is calculated in months, not weeks.
Especially if you got 30 years with the previous company. That could be expensive for this company.
It
right?
could. They could owe him as much as 2 years' pay, even though he's only worked there for a year. So if you've been recruited from another job, even more important than ever, to get advice, make sure you get what you're owed.
Inducement, the legal term, right?
That's the term, exactly, John.
Again, terminationquestions.com. Thank you, Ishan. Appreciate that. You want to reach out to a phone call as we close off for another show. Here's how you do it, 1-855-821-5900. All those phone calls came from employmentlawyer.ca. That's our radio show. And finally, the email address, help@employmentlawyer.ca. Write in, ask the questions. They will be answered by a member of Lior and his team. Really quickly, we'll catch you again next time, Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.